The Department of Justice has just announced, Merrick Garland actually, the Justice Department strongly disagrees with the Fifth Circuit decision in Alliance for Hippocratic Medicine versus the FDA, deny in part our request for a stay pending appeal. So the Fifth Circuit ruled in the case, and it was not a complete victory for the pro-life side either, by the way, but it did not give the Department of Justice the stretch of what they want in these abortion-oriented regulations.
The underlying district court had said, yeah, the FDA messed up, we're pulling the drug off, or putting a hold on the drug.
That's not what the Fifth Circuit said.
The Fifth Circuit said, we're going back to the original FDA ruling, which allows it up to 7 weeks and does not allow it by mail.
Was that enough for the Department of Justice? And the answer is no, which shows you how pro-abortion this Department of Justice is. They want it by mail, which was not in the original regs. They want it to go up until 10 weeks, that not in the regs. And so when you look at the situation, what they're asking for, they're asking more than the original regs allowed. And I think this is important, Logan, for people to understand. There's it sounds very technical, the Administrative Procedures Act, but there are rules and regulations that come into existence that affect everybody. I mean, the rules and regs basically are bigger than the laws, but you've got to follow procedures to put those in place. The Department of Health and Human Services did not do that. And by the way, it's run by Secretary Becerra, who is the most pro-abortion cabinet member in U.S. history.
This just is from Sunday. This is after the district ruling, so let's take a listen. This is on Dana Bash.
Are you taking it off the table that you will recommend the FDA ignore a ban?
Everything is on the table. The president said that way back when the Dobbs decision came out. Every option is on the table.
Talk about abortion distortion. Let me tell you what the context of that question was. And that was Congresswoman Cortez and some others said, you know what the FDA should do? Ignore the court's decision. Not like appeal it, which they have the right to do that, sure. Ignore it. They're not right. We don't. So could you imagine? We have opinions now that Supreme Court issues. We don't like them. We just ignore them. That's what they're saying.
Yeah, and you have Secretary Becerra actually kind of saying, well,
everything's on the table.
Everything is on the table. Well, if that's the case, then that's true for every law, and then you're opening up a door you do not want to.
This is the good thing about Dobbs. It removes this badge of constitutional protection that didn't exist in the Constitution itself. But it removes this ability to hold this over the head of any pro-life legislation. The problem now is you've got to be very strategic. During the break, I just talked to a couple of our lawyers and said, hey, this thing's moving to the Supreme Court today. Depending on what they file, we need to be prepared to take – we've already filed in these cases going up. We need to be prepared for the next step. But this is the nature of the abortion fight now, folks. It is really complex. It is very serious. And the removal of the safeguards here is to increase the number of abortions, plain and simple.
The Biden administration is 100% pro-abortion, and they don't want to accept 7 weeks and, doctor's review and it can't be by mail. They don't want that. They want it to be as broad and liberal as it can, and they would kick it even further than the 10 weeks and by mail if they could. I guarantee you, because we've seen the administration.
They'll try if they continue to control it. These agencies, they love these agencies, love this, and the leaders of these agencies are the most pro-abortion cabinet members in U.S. history. Let's not make any mistake about it.
The Supreme Court of the United States was absolutely correct in Dobbs. I defy anybody to find me a right to abortion enshrined in the federal Constitution. It simply is not there. So now we're trying to get around it by these various means. It's not going to succeed, God willing.
They'll probably file a motion for a stay, and in the alternative, a motion for a petition for certiorari. That's normally how they're done. We've done a lot of Supreme Court practice. What we don't know, they haven't filed it. I mean, as we're live right now, if you're hearing this tape delayed, they probably have filed it by then because they say they're going to go do it today. So this is going to move very quickly in the courts. I'm talking about days here, not months.